we brought this action to try to make sure that the county will comply with the federal constitution. If there is a nuisance on a property, then the county can come in and force people to correct that nuisance. But they can't be using their nuisance abatement program for cash generation and just extracting as much money as they can through coercive and extortive means out of the community. Yeah, we filed a class action lawsuit against Humboldt County alleging that their cannabis abatement program violates the United States Constitution in 5 different ways. And the cannabis abatement program, after marijuana got legalized recreationally in California, the county passed all sorts of land use ordinances about permits to build buildings and stuff. And this is after decades here in Humboldt where the county had let all of these ordinances go unenforced, so people have spent decades building outbuildings on their property, and timber companies have been grading land without permits for decades. And now the county has come in after marijuana was legalized and said any permitting violation that has been committed, if it has a connection to marijuana, then the daily fine for that violation is $10,000. So the county will use a satellite program and find people who have greenhouses on their property, and without visiting the property or doing any sort of inspection, they will say, you must be growing marijuana in that greenhouse, because why else would you have a greenhouse on your property? And if you built that greenhouse without a permit to grow marijuana, it's a $10,000 fine, plus another $10,000 fine for growing marijuana without a permit. Plus, you can't build a greenhouse if you didn't grade the land, and grading land without a permit to grow marijuana is another $10,000 fine. So on average, the county will come in and allege 3 violations, each of which carry a $10,000 daily penalty. And these penalties will run for 90 days. So very quickly, the penalties rack up into the millions of dollars. Like one of our clients in this lawsuit that we brought faced $7.4 million in fines over some hoop houses that were on her property when she purchased it that she took down immediately. And no matter what she does, no matter what these people do, they can't get out of the fines, because the abatement program that the county created is designed to pressure people into settlement. And so we've stepped in and asked the federal court to rule that Humboldt County has violated the United States Constitution in 5 ways. The Constitution guarantees due process, and that means that you are entitled to a timely hearing and a meaningful hearing. And the way they've set up their system, there is no meaningful opportunity to be heard. Blue Graham, who I mentioned before, he waited 4.5 years for a hearing. He asked for a hearing, and every year the county says, are you sure that you want a hearing? How about you sign this settlement agreement instead? And they just don't give you your day in court. And then once you do get your day in court, it's before a law firm that the county hired to decide cases on their behalf. And as code enforcement officers warned Blue Graham, the county does not lose cases before the law firm that it hired. So even when you do get your day in court, you're going into a rigged system, and they're also just doing all sorts of, like, it's death by 1,000 cuts, because they predate the notice of violation that they send to people. You only get 10 days to respond to the notice of violation, but it's always dated a couple days before you get it, and they post it on your property on a Friday and don't give you any notice that they're posting it. And so then, next thing you know, you have 4 or 5 days to tear down a 3-story building on your property, or you face millions of dollars in fines. So they put people in these situations where they simply can't get out, and they feel like their only option is to enter these compliance agreements. And the compliance agreements come with thousands of dollars in fines. They usually offer to settle for 1 day's worth of fines, so for a lot of people that's $30,000, and the average yearly income in Humboldt County is below $30,000. So the average settlement that they're offering people is a year's worth of gross income, and They're finding people at a house at home. There's a few dozen properties now that have $900,000 liens against them because of the abatement program, and they're doing all of this without providing people a meaningful opportunity to show that they haven't actually grown cannabis on their property. And so that's one, is that due process issue. Two, it's something in the law they call substantive due process, and basically what it means is that the government is punishing you for something that the government doesn't actually have an interest in stopping. Like, you have a right to use your land how you want, as long as you're not harming your neighbors. And the Humboldt County has come in, two of our clients, we call them innocent owners. They purchased properties that a prior owner once grew cannabis on, and the county has admitted that they have never grown cannabis on their property. But because the prior owner did, they need to tear down any structure and regrade any land that cannabis has touched. Because once a building has been tainted with cannabis, it needs to be torn down, even if you weren't the person that put cannabis inside of it. And our argument is that our clients have done nothing wrong, and the county has no interest in forcing them to destroy perfectly good buildings just because someone else once put cannabis in them. And so that's our substantive due process. And three is the excessive fines clause, which is like pretty easy to understand because they're fining people millions of dollars for having temporary greenhouses on their property. And four is the unconstitutional conditions, and that's what I described with Blue Graham, where they're basically denying you other benefits that you're entitled to unless you settle your case, your unrelated abatement case with them. And so, like, you can kind of think about it as like government-backed extortion. That's the unconstitutional conditions. And then the fifth issue is a Seventh Amendment claim that the county is denying people a right to a jury of their peers. And the county law says that this abatement program, the purpose of it is because it's more efficient than going through the criminal justice system. And so they are bringing these millions of dollars worth of fines against people, and you don't have the right to a jury. Like I mentioned, you only have this law firm that they hired to decide your case, and the facts in these cases are they're very determinative. Like, whether or not you intended to grow cannabis in this greenhouse that you built determines whether it's like $100 fine or a $10,000 fine. And so that's a question of fact that should be determined by a jury and not by some lawyer that the county hired. And so those are our five claims: procedural due process, substantive due process, excessive fines, unconstitutional conditions, and the right to a jury. And our argument is that in those five ways, Humboldt County's cannabis abatement program violates the United States Constitution.
Or no, but in layman's terms.
Yeah.
Right.
Well,
it sounds like extortion.
And like, I think, like, as lawyers, you're hesitant to throw that word around because, like,
right.
It has, like, a legal meaning. But
yes.
The Supreme Court cases that have ruled that this type of behavior is unconstitutional, they describe it as extortive.
Okay, so this is an appropriate use of the word.
Yeah, like saying, like, in a lot of these cases, it'll be like, we will only give you a permit unless you give us part of your property. We want an easement over your land, so we're not going to give you the permit that you need to build your house unless you give us a access.
Yeah.
So it'll be something like that, and the Supreme Court has held you can't deny people a discretionary benefit by withholding some constitutional right that they have. They're asking Blue to give up his property interest in things. They're asking Blue to give up his due process rights. They're asking him to give up his right to have a hearing. And he can't get his permit for his house that he needs, and he will then face even more fines if he has an unpermitted house. And the Safe Home program is about to end in December, and he knows that, and they know that. And so they said, sign this agreement, or like you're not getting a permit for your house.
So, this is a class action lawsuit, correct?
That's right.
Now, how can people get on board with that?
So, there's a couple types of class actions, and without having to get into all the minutia, the way this one works, it's a class action for prospective relief. And so that means we're asking the court for forward-looking relief, and when that's the case, people don't have to do anything to get involved.
Okay.
So what we've proposed to the court is that our class will consist of everybody who has gotten a notice of violation since 2018 and who sought an appeal in their case and never received a hearing. So those are basically like the three criteria, and if you meet those three criteria, as long as the court agrees that we're entitled to have a class, then you would those people would automatically become part of the class.
Okay.
But we have asked, there's people that have like, part of the way that this case has been like sort of hard to like boil down into digestive form is that the county has the blueprint is always like put pressure on people to settle, but that sort of comes up in different ways in different cases. And so everybody's facts are a little different, and some people have been extorted into settlements, and some people rather than sending in their attachment C to ask for an appeal, they just sent in proof that there was no cannabis and there was no more greenhouse on their property. So they, in their mind, they did everything that the notice of violation required them to do. They abated the alleged nuisance, and they thought the case would go away. And then a year later, they get a settlement agreement in the mail from the county saying, like, you still owe us money. And so there's lots of iterations of the way the county has been harming people that don't fit neatly into that box. And we have asked that if people think that they have an action against the county, that they reach out to us, and we'd be happy to talk to them and see if they have a viable claim that might be worth adding to the case. But from like a class perspective and whether you're included in a class, that just happens automatically.
Got it. Okay, thank you for explaining that. And before we get into the town hall here, we're about to hear from plaintiffs, I think, and community members. I'm assuming more people will jump in to talk.
Yeah, I think the important thing here is that there are a lot of people in Humboldt County who are just like really hurting at a human level, and they've come out here. A lot of them live off the grid, and they moved to Humboldt for the right to be left alone, and they achieved that for decades. And now, after legalization, the county thought that it would be making more money than it was, or whatever their motive is, and they have used that as a hook to reach out through their satellite images and through their code enforcement to reel these people in and try to squeeze them for every dollar that they have. And there's no constitutional process in place, and we brought this action to try to make sure that the county will comply with the federal constitution. If there is a nuisance on a property, then the county can come in and force people to correct that nuisance. But they can't be using their nuisance abatement program for cash generation and just extracting as much money as they can through coercive and extortive means out of the community.
Okay. Thank you for that. I appreciate your time.
Yeah, I appreciate yours.